I'm telling you, the people who wind up like Mr. Williams are few and far in between. Get your education. What do I tell you guys? What do I tell every one of you guys? Build your education, build your financial future, build your relationships with your woman, with your family, with your mom, with your brother, with your sister, and build those relationships. You got people dragging you down. You have to look over your shoulder because you just did something that the police are going to come. Don't be that guy, and idolizing drill and the things that they do in drill and just the whole gangster culture and lifestyle, it isn't safe for you. It just isn't. The prosecutor was asking for 45 years, 25 years in, 20 years on probation, and with all these conditions. But the problem is that you have a situation where just hours earlier, she was willing to give him just probation. How do you square that?
The recommendation that the state previously made prior to us reaching this point was made with the hope that Mr. Williams would agree to certain special conditions of probation that we asked.
He entered into a nolo contendere plea and a non-negotiated plea. What is a non-negotiated plea? That's where you don't have any agreement with the prosecutor except for the things that you're pleading guilty to, and it's an open sentence. So you can ask for whatever you're going to ask for, and the prosecution's going to ask for whatever they're going to ask for.
Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. And what he do? And it's going to react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, your personal board-certified criminal defense lawyer, here with an update on the YSL breaking news with our content genius. The breaking news is that YSL, or Young Thug, Jeffrey Williams, has taken a deal. He has pled guilty to a bunch of stuff, and we're going to get into that. But before we do, guess what this is brought to you by? Our loyal sponsor. Say hello to eForms.com. eForms.com is a very effective way to remotely, because it's remote, you do it on your computer, but to get any legal form that you need, whether it's power of attorney or if you need to reestablish yourself out in the market because your grandma's going to be rapping and you need contracts. Well, you need a business agreement. You need a bill of sale because you're going to sell some things in order to pay for your microphones and all that kind of stuff because your grandma is rapping in her basement, but she needs to get out there. So you go to eForms.com. Or if your grandma's delusional and she thinks she's going to rap, well, she needs a power of attorney, so you need to take care of her. Anyway, go to eForms.com, a very effective way to stay out of court or to win when you get there because the documents don't lie. eForms.com. Christmas is just around the corner, and if you don't have your CLR sweatshirt, if you're not sporting that sweatshirt or your hoodie or your hat or whatever, something's wrong with you. So make sure you go to clrbrucerivers.com. Okay, now Young Thug, Jeffrey Williams, he turned down a deal earlier today with an agreement with the prosecutor that would allow him to be released today with 15 years of probation. This is according to the Atlanta Journal-Constitution. It would have been, and then so he rejected the deal because he didn't like the conditions of probation. I think it was because he wanted to be able to still associate with some of the people he was making music with. And some of those people the state was saying are gang members. And so you can't have any contact with gang members. So he rejected that. But in late breaking news, just off the presses, he entered into a nolo contendere plea and a non-negotiated plea. What is a non-negotiated plea? That's where you don't have any agreement with the prosecutor except for the things that you're pleading guilty to, and it's an open sentence. So you can ask for whatever you're going to ask for. The prosecution's going to ask for whatever they're going to ask for. But here's what I don't like about the prosecution in this case. You got a straight plea. On the one hand, they were willing to let you walk free. On the other hand, now they're asking for 40 years, 15 years of probation. 25 years in custody and 20 years probation. So how is it that you, on the one hand, you say, oh, this guy's such a danger, but I'm going to let him go free if he does exactly what I say. Otherwise, we're going to ask for 40 years, 45 years. That's ridiculous. And I think the judge saw through this. So, but this plea comes on the heels of 3 other pleas that went down this week in this case. This week, the judge approved of plea deals for 3 of them. Quamarvius, right? Quamarvius Nichols, 29 years old. Marquavius Huey, 28 years old. And Rodalius Ryan, 18 years old. One of them's already serving a life sentence for murder, and he got 10 years. The other 2 were time served. So one of the things that you look for in sentencing is you want to avoid disparities in sentencing. So even though he's at the top of the list, for the indictment, how do you let other people go free and give such lenient sentences? But at the same time, you're asking for 45 years, So these men all face multiple counts of various racketeering and gang-related charges, each potentially carrying a prison sentence of 5 to 20 years, with all of them agreeing to plead guilty to racketeering conspiracy, with Huey also pleading guilty to other reduced charges. They accepted more lenient prison sentences with probation and time served. Ryan, however, will remain in prison on a life sentence for 2019 murder, but his 10-year prison sentence in the RICO case has been commuted to time served. So what does that mean for Thug, for Mr. Williams? Well, he pled guilty to count 1, nolo contendere. That means no contest. It means you don't agree with it. You're not saying that you're guilty, but, you're just letting the conviction stand. 20 years, commuted to 5, served 15 on probation, $25,000 fine. Count 2, 5 years consecutive. Count 58, let's see, count 7, 8, 15, 9, 60, 61, 62. So basically 6 other counts that related to either firearms or gang-related charges. So let's kind of look and see how the prosecutor came off. So we're not going to, there's 2 parts to a guilty plea. The first part is a waiver of your constitutional rights. We're not going to watch that because it's kind of boring. You have the right to a trial, blah, 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 and you waive all your constitutional rights. Then the second part is a factual basis. Now, the factual basis is you usually ask the defendant questions. Is it true that on this date this happened? But in this case, since it's a nolo contendere plea, the prosecution gets up and says their piece, and then the defense gets up and says their piece.
Agreed to certain special conditions of probation that we asked him to adhere to, and that he would take ownership and responsibility for being the leader of YSL. Given that those negotiations have broken down, we are asking that the court sentence Mr. Williams as we have asked earlier. And prior to the court imposing a sentence, we would ask that Ms. Shawana Edmonds, who is the mother of Mr. Thomas.
So he entered a plea, and basically what she was asking for are 2 things. One, the death of Thomas, that was part of this case, but they dismissed the murder charge against not just Thug, but other people. And so she wants the family member of Thomas to give an impact statement, and the judge denies that. And the prosecutor was asking for 45 years, 25 years in, 20 years on probation, and with all these conditions. But the problem is that you have a situation where just hours earlier, she was willing to give him just probation. How do you square that? You don't have any credibility with the court when you do that. All right, let's see what Thug's lawyer was asking for in his solicitation or recitation.
Many pieces of evidence, and then took liberty that is the state's theory. Mr. Williams has tendered a nolo contendere plea to the RICO conspiracy count. I can see that.
Okay. All right, I didn't mean to interrupt you.
No, it's fine. And Your Honor, I'll answer any of your questions, but the point I'm trying to make is 45 years to serve 25 years in prison, when just this morning it was a probationary offer. It was a probationary offer. The state knows.
That is not lost on the court. A probationary, you go from 0 to you got to serve 25 years in prison. How do you do that?
But they want to control. They have this theory of music, and they want to stop Mr. Williams from making music, from entertaining, just stop his life. That's just not right. And it's wrong of the district attorney in Fulton County to do that. If they offer probation, then he's not a 45 to serve 25 years in custody type of person, and he's certainly not the person that the state has stated in front of the court. What we're asking, Your Honor, on count 1, which is the RICO count, to accept the nolo contendere plea. Please sentence Mr. Williams to 20 years to serve 5 years in prison commuted to time served. Mr. Williams has served, as I said, 22.5 years. On count 56, Your Honor, that's the leadership of a gang, nolo plea, 20 years to serve 5 years commuted to time served, consecutive to all other counts. On count 57, which is a gang count, Your Honor, not a leader, guilty plea, 20 years to serve 5 years commuted to time served, concurrent with count 1. With regard to count 58, which is possession of, I believe it is marijuana with intent to distribute, 10-year sentence on probation, concurrent with count 1. On count 59, which is violation of Georgia Controlled Substance Act, possession of codeine with intent to distribute, 5 years on probation, concurrent with count 1. On count 59, Your Honor, which is violation of Georgia Controlled Substance Act, possession of cocaine, 3 years on probation, concurrent with count 1. Count 61, 5 years of probation. It's a firearm count, consecutive to the other counts, consecutive to before count 56. And then count 62, 10 years to serve commuted to time served. That should be a total sentence, Your Honor, that we are respectfully requesting the court to consider. I believe it's 45 years to serve 5 years in prison, commuted to time served, 40 years on probation, credit for the time already served and community time served. As I said, after 3 years of probation, the probation becomes non-reporting, and after successful completion of 10 years on probation, the balance of the sentence be terminated. Mr. Williams asked the court for house arrest for 3 years as part of the sentence, but house arrest specifically defined that Mr. Williams will be in his home.
So he's asking for house arrest for 3 years. He's asking for 40 years of probation to be terminated after 10 if he successfully completes probation. That's common. And now let's fast forward to see what the judge actually does here, because I find the judge's remarks quite something.
I did more than anybody ever did from my side, you know. But I understand, you know, rap lyrics. I understand how it could be twisted. I understand what it could do to the mind of people. I understand all that, and I promise you I'm 100% changing that. You know, it's just, I'm older, I'm grown now, you know, and it's just like, I'm smarter. It's more things to rap about. Like, I've experienced a lot of good things. I experienced more bad things, but I experienced a lot of good things too. And anyway, I can go forever. Well,
I appreciate it. And I appreciate that you do realize how much of an impact you have on people. I mean, it's past your neighborhood. It's worldwide, especially young people. And having come up from where you came up from and living.
One of the things the judge does is gives kind of a speech, you know, because it's not just for the person that's standing in front of you. It's for the general public as well. And so they give kind of a moralistic, you need to be a better person, you need to do this and that.
In and around that, that gangs are damaging to our community. And it may be that a whole lot of rap music and the rap industry is, honestly, it sounds like a modern day version of kind of WWE wrestling that used to be on television, where people would just get up and posture and act like they hated each other. And it may be that that's a lot of what.
So the judge seems really fucking naive here, honestly, when she sits there and talks about WWE, World Wide Wrestling, or WWF or whatever the hell it's called. Like, this is fake. So one of the things that the defense lawyer brought up was that the rap battles, and it's more like the WWE, the worldwide. One of the things the defense lawyer brought up was that this is, these rap battles, the lyrics, and the culture is just like WWE, like the wrestling, which is just bullshit because, we see people getting shot up. Lil Wayne's bus got shot up, riddled with bullets. We say Julio Fulio. And then they go back and forth with these diss tracks. And so the judge is talking about this as though it's, it's not real. And it's just, we all know better, don't we?
In the music industry with rap. But whether it is fake.
It ain't just rap. It's drill. And, and there's a big difference between just regular rap and drill.
Whether it is fake or not, it has tremendous impact on kids and young people who think, this is cool, this is what I want to do, look at him, he's a millionaire, I can do that by being, a gangster in the streets. And that's not true. What you're likely to have happen to you if you're a gangster in the streets is you get shot, you get killed, or you get thrown in prison.
Facts. Straight up facts. I'm telling you, the people who wind up like Mr. Williams are few and far fucking between. Get your education. What do I tell you guys? What do I tell every one of you guys? Build your education, build your financial future, build your relationships with your woman, with your family, with your mom, with your brother, with your sister, and build those relationships. You got people dragging you down. You have to look over your shoulder because you just did something that the police are going to come. Don't be that guy, and idolizing drill and the things that they do in drill and just the whole gangster culture and lifestyle, it isn't safe for you. It just isn't.
And those are, by far the most likely outcomes. And, you've been in here watching the trial, and you've seen the pictures of Mr. Ryan posing with a gun as big as he is at 15 years old and going out and shooting and killing another teenager. And that's what gangs do, and that's unfortunately a lot of what rap music does.
Let's just make sure that she knows that isn't what rap does. Maybe drill, but not rap in general. I think that's a broad brush.
And if you are a modern day John Lennon, he might have rapped too in this day and age. I don't know, but I know you're talented, and even if you choose to continue to rap, you need to try to use your influence to let kids know that that is not the way to go, and that there are ways out of poverty besides hooking up with the powerful guy at the end of the street selling drugs.
That powerful guy at the end of the street is really not that powerful. And why not? Because guess what? The government's made of fucking snitches. And I guarantee you that did not have, the fact that 3 other people took a deal that may have included cooperation had a definite impact on whether Thug was going to take a deal. And so that powerful guy who's driving the tricked out Cutlass down the road, you know, and I'm telling you, that's, what do I call that? You guys know what I call that. Short money. You know, that's just short money. That's, I mean, yeah, you might be flush right now, but if you can't keep it, and if it's going to go through your fingers like that, it's not worth, you know, the risk that you have to go through to get it.
And, you know, I know that happens for protection sometimes, but a much better way would be getting an education and setting, you know, hanging around with people who set a good example. And you be one of those people that sets a good example. I mean, all right, so that's my high horse on that. I could also go.
And that wasn't that long of a speech by a judge. You know, this was how long of a trial? He's been in there 2.5 fucking years. 2.5 years. Since May of 2022.
But I want you to try to be more of the solution and less of the problem. All right? All right. So it is not lost on the court that the state, had they been able to come to agreement on certain special conditions, was willing to entirely dismiss the RICO count, was willing to entirely dismiss one of the gang counts, and was willing to entirely dismiss this, you know, machine gun count. Was willing to give a sentence that permitted Mr. Williams to walk out of the door today.
I mean, how do you go from you can go home now to you're going to do 25 years in prison, then 15 or 20 years on probation? How do you square that? You know, if it's that much of a fucking danger, it's, you know, before you walked into court today, how is it, you know, convenient for you? It just doesn't square.
And therefore does not seem to be particularly worried that Mr. Williams, if on the streets, would be a danger to society. I'm taking that into consideration in crafting my sentence. And in permitting a NOLO plea to the RICO count and one of the 2 gang counts, I would not be permitting the NOLO to the one if you were not pleading guilty to at least one of them. But you are.
And a judge can blow up a plea. You know, if all of a sudden you're not taking responsibility or you're not really pleading guilty, or if the deal is just, you know, a shitty deal, the judge doesn't have to accept the plea. Judge can say, you know what, we're going to see what the jury says.
A factual basis for the counts that you are pleading guilty to. I find there to be a factual basis for those counts, and for the remaining counts with which you are charged. I am going to impose a sentence, and I've taken a little bit of the suggested special conditions from the defense and a little bit of the special conditions suggested by the prosecution. On count 1, the court sentence is 20 years to serve 5 years, commuted to time served, the balance of 15 years to be probated, and a $25,000 fine. On count 2, the sentence is 5 years to serve, commuted to time served. That's the minimum sentence that's permitted on that count. It is required to be run consecutively. I'm going to run it consecutive to count 1, but I am going to backload. Oh, I'm sorry, that is not.
So what she means by backload is you're going to be on probation for X amount of time, and in this case, it's going to be 15 years. I'm not going to make you do that time now. I'm going to make you do that time, that consecutive time. So sentences can be concurrent or consecutive. Concurrent is meaning you do it at the same time. If I got 2 counts to do concurrent, it's 5 years at the same time. You know, if I do have 2 5-year terms consecutive, that's 10 years, 5 one after the other. So you have to do this other 5 years, but I'm going to load it on the back end. And as long as you're doing okay on probation, you successfully complete probation, that 5 years goes away.
Commuted. That is 5 years to serve, and it's going to be run consecutively to count one, backloaded, by which I mean after you serve your 15 years of probation, if you have been successful on that probation, and I sincerely hope that you are, then at the end of that 15 years, I will commute the entire rest of any service portion of your sentence to time served. So I'll get to the end of it and give you the total sentence, but I'm also going to impose a $15,000 fine with regard to that count. Count 57, 20 years to serve 5, commuted to time served, the balance of 15 years probated, concurrent with count 1. Count 58, 10 years to serve 5, commuted to time served, balance probated, concurrent with count 1. 59, 5 years to serve, commuted to time served, concurrent with count 1. 60, 5 years to serve, commuted to time served, concurrent with count 1. Count 61, 5 years to serve, that is required to be also a consecutive sentence, so that's going to be run consecutively to count 56 and backloaded. Count 62, 10 years to serve, also required to be served consecutively, that's going to be consecutive to count 61, also backloaded.
So that's 25 years that's backloaded. So he's not out of the woods quite yet. So if he screws up on probation, he can do, time on the stuff that's been probated, in other words, probationary sentence, because you have time hanging over your head on these probated sentences. And then you're going to have to do this other 25 years after you're done with that other time. So that he's got an incentive to really watch his P's and Q's, for lack of a better word.
So essentially, the total sentence is 40 years to serve the first 5 years in prison, but commuted to the time that you have already served, followed by 15 years on probation, followed then by backloaded 20 years, which can be served in custody and will be served in custody if you are not successful on your probation. If you are successful in completing your 15 years probation, that will be commuted to time served.
So essentially, on probation for 15 years, we got time on those counts that are being probated. In other words, you're on probation, but on those, there's time hanging over your head. So when you have 5 years on a 20-year sentence, credit time served, but the rest to be probated, that means 15 years on count 1 that's probated. You screw up on probation, you can get you can do that 15 years. But on top of that, you're going to do that 20 years that she's backloading. Make sense?
You are to remain on reporting status for the first half of your probation, active reporting for the first 7.5 years of your probation, and that is...
So that means you're on supervised probation for the first half of your probation. So in other words, you got to call in, you got to piss test, you got to do all kinds of stuff that your probation officer asks you to community service, and she's going to load them up with all kinds of conditions.
Pursuant to OCGA 17-10-1, subsection A2A. And Mr. Steele and Mr. Adams, in order to keep him on reporting status, there needs to be good cause shown. We all concede that good cause is shown here?
Stipulate.
All right, I appreciate that. Special conditions of your probation.
What good cause? What do they mean?
Can I have a second, Your Honor?
Sure.
Let the judge. Thank you, Your Honor.
All right. You had enough time to talk with your attorneys?
Yes.
Okay. All right, special conditions of your probation. After 48 hours from your release, you are to stay away from the metro Atlanta area and that's defined by the U.S. Census Bureau. It may change, but
That is not a common condition that you stay out of a particular area, but it is in this case because it was such a infiltrated gang
figure
type
out
case.
what that is. For the first 10 years of your probation, subject to the following exceptions, you are permitted to be in the metro Atlanta area to attend any wedding, funeral, or graduation from high school, college, or graduate school of any of your immediate family members. And immediate family members is defined the same way that you are.
So, without going through all the conditions, I'll just kind of briefly summarize. When you're on probation, the court can impose conditions of your probation. And one of the things she's 4 times a year, he's got to do anti-gun, anti-gang presentations, either to a school or a benefit concert, that kind of thing. And that can satisfy his community service. There's no contact with gang members except for his brother, who they conceded was a gang member, or people that he's got a contractual obligation, like people that he's making music with. And I think that was the big stickler, my guess, is on the probationary things that they had, why they couldn't come to a deal. And and here's the kicker: no promotion of gang activity or gang speech or anything that has to do with gangs. This may really impact the way he has his music done in the future. But I guarantee you he's going to be singing about being in a jail cell. Because what do you think he knows about right now? That's fresh in his mind. I guess, guarantee you that's going to be in some of his future music. Random drug testing, waiver of searching his person or his premises for drugs. That's standard conditions. But the judge didn't impose some of the conditions that his own lawyer asked for, like home monitoring. No home monitoring was ordered. So really good day for the defense here. I think he got pretty much everything he wanted. No further prison time or jail time as long as he keeps his nose clean. Otherwise, he's looking at 40 plus years. 40 plus years. Can you imagine? I mean, how did the state go from 45 years to probation? It just seems to me that the state's case crumbled out from underneath it. So when you look at the sentence overall, for a 32, 33-year-old man to get a 40-year sentence, that's essentially a life sentence. So it is, even though he's walking out today, it isn't like he's free. The government still has a hold on him. He's going to be on probation for 15 years. 7.5 is going to be supervised. 7.5 is going to be unsupervised. He can still move out to California. He can still perform and do whatever he's supposed to do, but he's going to have to be sober. How fucking hard is it for these guys to be sober? I mean, smoking weed is like in some people's DNA, and weed is so popular. And try to go to a concert and not smell some weed. I mean, honestly. So you're going to have that. My guess, he's probably going to have a doctor prescribe it for him because if a doctor prescribes it, you're going to be okay. So he's going to have to be sober. He's going to have to be law-abiding. He can't be with any gang members unless they're in the exception. And he's going to have some limitations on his actual freedom, where he can go and when he can go there. So this is not just he walks, and if he screws up at all, he can go to prison for an awfully long time. So that's our update on the breaking news that Young Thug took a deal. He's been sentenced today. And we'll see you next time here at Criminal Lawyer Reacts. And make sure you go to clrbrucerivers.com, say hello to Tony and anybody else that's responsible for the content that's created there. You can get whatever merch. Christmas is just around the corner. And if you don't have your CLR sweatshirt, if you're not sporting that sweatshirt or your hoodie or your hat or whatever, something's wrong with you. So make sure you go to clrbrucerivers.com. See you next time here on Criminal Lawyer Reacts. I'm Bruce Rivers. Make sure you subscribe, follow us on Instagram, follow us on Twitter, sign up for Patreon, and we'll see you next time on Criminal Lawyer Reacts.
Take Mr. Steele into custody, please.
His lawyer's getting fucking arrested. He's getting arrested in court.
I also do not.
Well, I asked him, so I didn't ask you.
Yeah.
I'm not a fan of this kind of judge action. What's the purpose? He wants to take somebody to the woodshed. That's the retribution. That's the only thing he wants it for. Brian Steele's a good lawyer, and he's going to the mat for his client. One rule of thumb, for any good criminal defense lawyer, if someone's got to go to jail, make sure it's not you. It's getting a little out of control, don't you think?
Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. And what he do? And he's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, your very own personal board-certified criminal defense lawyer. We've been gone for a little bit. We've been on vacation. We've been working. We've been doing all kinds of stuff. Michael's been a little bit sick. But it doesn't really matter because we are back in action, back in the saddle, back with the man with the plan, back with the man behind the camera, behind every idea, the man shaking his head at me right now, Michael Rivers, our content genius. Today we're reacting to the YSL trial. The YSL is, the Young Slime Life or whatever you want, or Yves Saint Laurent. I think that's what his lawyer tried to convince us. Let's just give a little background of the YSL trial, what's going on there, and what's happening with Brian Steele and his headbutting with the court. But before we get to that, I've been taking care of my grandma, and she's rebounded. She's got this new fitness thing she's doing. And, it's grandma in the basement doing aerobics and spandex, and some people are into that. Well, what did she have to do? She had to get a business agreement and a business license and all that kind of stuff. So she goes to eform.com. eforms.com to for any business forms that your grandma might need or you might need. So, for example, if you have a car and you want to sell your car, well, you know what? If you don't have an agreement and you just sell your car and you think the guy's going to transfer the title, he might not. You need that agreement to have that enforceable agreement in writing. Or if you need a power of attorney, say your grandma's in your basement doing all kinds of crazy shit, get your grandma a power of attorney and you take care of her, take care of whatever you need to take care of. Doesn't matter whether it's your grandma or a family member. Any legal form you need, you go to eforms.com. eforms.com, it'll keep you out of court and it will keep you away from expensive lawyers like me. Okay, now let's talk about the YSL. YSL is a Fulton County prosecution where she's prosecuting a bunch of, she's claiming they're gang members, but it is what it is. And I think there's like 20 some, or I don't know how many are left, but there's quite a few. A lot of them pled, but a lot of them are left. So, and it's a RICO case. So there's various different kinds of overt acts related to this RICO prosecution. Murder, drugs, assault, theft, a whole host of things. Well, so what happens when you have a gang trial like this? Nobody wants to testify. And if they do testify, they want to get something for it. They want to if they're going to cooperate, they got to get paid, right? And paid means less time on another case usually. They had this witness testifying, Lil Woody, I think is his name, Kenneth Copeland. And he's testifying, but he's kind of not really being cooperative on the stand. And then he tries to take the fifth. We're going to play a little bit of his stuff a little bit later to show you what this is about. But apparently they had some kind of in-chambers conversation with either him or another witness. But they had an in-chambers conversation. They did not notify the defense. And whatever the issue was, whether it's a safety issue or if it's a right to counsel issue, the prosecutor and the judge went into chambers, had an in-chambers conversation with a witness that was already sworn in and didn't tell the defense. We're going to watch how Brian Steele gets pissed off here, and he should have gotten pissed off. So, I'm just not a fan of doing things outside the presence of either party, but it's called ex parte. That's what they call when you have an ex parte communication. That means the other party is not there. So, and keep in mind that Young Thug has been in custody for 2 years. 2 years. And he hasn't been convicted of a thing. I'm not a fan of this judge. At the beginning of this, I didn't really take a position on. But when you have a jury selection that takes 10 fucking months, it shouldn't take that long. You do this in federal court, maybe a week, maybe a month, maybe a month because of all the defendants. Judge is just not really taking charge. But let's watch this and see what happens. Brian Steele's a good lawyer, and he's going to the mat for his client.
All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And
The defense is about to make a motion for a mistrial based on this in-camera review. And what this is basically is an in-camera review is where the judge it can be documents, but has a sworn witness who's already been on the fucking stand and doesn't notify the defense that we're doing this review of the witness and questioning the witness after they've been sworn in camera.
And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And
So what the judge is basically saying here is, okay, because he says, I know you've had this conversation. I know that Kenneth Copeland was in your chambers with the prosecutor, and I want to know why we weren't informed of that, why we weren't part of that, and this is a witness that's already been sworn, it's been on the stand. What the fuck? I mean, that's basically Brian Steele's attitude.
gives me no joy, but as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, let me just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information.
So we're going on a 1.5-year prosecution, just about. You know, there's just no way this trial should take this long. No way. And now this judge is getting animated with Brian Steele. So the issue, there's two issues here as I see it. One is Young Thug being denied presence at a critical stage of the proceedings, and it really is kind of a critical stage. And does the judge have the power to issue an order ordering defense counsel to disclose how he obtained certain information, or if it's protected by some privilege, like work product privilege? And that's what the 1.6 comment 5, that's what Brian Steele is talking about, that this is protected work product.
If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand, and I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others.
So the way the judge said this tells me that Brian Steele knows what he's talking about, and he has accurate information.
It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there, and it shouldn't have happened.
Sir, that's a whole separate issue, and that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
So let's talk about ex parte. Ex parte means, okay, we have an issue with a witness, and judge, I want you to review this, but we don't want the other side there. Sometimes I've had situations where I have had ex parte communication with the court. For example, when you have multiple defendants and you are moving for severance and you have defenses that are antagonistic to each other, in other words, the defenses are going against each other, but you don't want to reveal your strategy to the other side, which you don't have to do, well, then you can ask for an in-camera review and have an ex parte communication with the judge. That's totally legitimate. But with a witness that's already been sworn, anything that comes out of that witness's mouth should be disclosed to the defense. And that's why Brian Steele's getting all animated.
Never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is, who?
You can tell the judge is getting frustrated. He's like, just fucking tell me.
How did you get this
I
information?
understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
They're talking past each other. Can you see that? I mean, he already knows the rule. You know blah blah blah.
You can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you. You're saying, you're threatening me with contempt.
Privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not some substance, but I'm telling you I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And
It seems to me that there would be a less onerous sanction than jailing the chief defendant's lawyer.
you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what.
So one of the things about contempt is he has the keys to the jail. He can purge the contempt by disclosing. But is he violating some of the rule by disclosing? Brian Steele seems to think that he is.
I understand the rule to be. I've not asked you some in substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea
wrong.
how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
You cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen, and listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
From whom?
part of it.
From whom? See, they're talking past each other. One rule of thumb, for any good criminal defense lawyer, if someone's got to go to jail, make sure it's not you.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you.
See, that means he knows the information he has is accurate.
So,
But you're assuming something because I told you already.
well, then, other than
Answer
if
that
you were
under
sitting, unless you were sitting in there with a recorder or Miss Love or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that was a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
But
about?
anyways, I'm not going to have a.
When I got this information.
I'm not going to have any further conversation
Well-
with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in
I
time.
think that the court needs to again
I have to say, in 26 and a half years of practice, I've never been taken into custody.
declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I
for
understand that you
mistrial.
spoke with a
And
witness outside of our presence.
And
this
whenever,
morning.
yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness.
So one of the reasons why it could be appropriate is because the person was in fear of testifying. They got a threat or something like that. And if the judge didn't want to disclose that to the defense at that moment, there's all kinds of other ways the judge could have done this, a protective order, But they do take, I'm sure there's a transcript of that testimony. So I don't think it's necessarily corrupt, but the defense should definitely be notified.
The witness based on information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
Why
that's for
did we
another
exclude
day.
in the first place? I didn't know about this stuff.
That's
I raised
for
it
another
before the
day.
court.
So
I raised it as soon as we found out about it.
well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
And what he's talking about there is, if it's a critical or material part of the case, the defendant has a right to be present. And any statement made by that witness is certainly subject to cross-examination and disclosure to the defense.
But you're acting like it's
Mr. Steele,
private.
that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. That I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it supposedly.
Does the state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is
What I don't get here is why Brian still keeps talking. I mean, you can tell the judge is in transit on this issue. He's not going to budge.
why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind
And
anything.
you can't hide behind, yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
It's probably a little nuts, lawyer, my guess.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So
I think the judge is wrong there. I think that Brian Steele is right, that under 1.6, comment 5, if he's got material evidence or information, he doesn't have to disclose it to the judge. The judge just wants it because he wants to make sure that he can take whoever gave him the information to the woodshed.
Honor, but that's the issue, isn't it?
well,
Why aren't we
well,
entitled to the
that's
But isn't that the issue?
that needs to be told. But
But,
State, do you have
right
anything more?
now, we don't know
Mr. Steele.
why we were excluded from that.
Mr. Steele,
And I want that information
stop.
because
Just
Mr.
stop.
Williams' constitutional right on
Just
the
stop.
Georgia Constitution.
Just stop at this point in time, because
Article 1,
because
Section 1, paragraph
you've
12.
already said that. You've already
The
said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
I mean, one of the things he's doing is making a record. He's making a record of his motion, and he's making a record of the ex parte communication that the judge had, and that his client wasn't included.
We're not waiving anything.
Yes, Madam, Ms. Lowe.
He essentially gets 20 days. He's going to have to do it on the weekends, 10 weekends, 2 days. That's what the judge got, or up to 20 days. But then he had other lawyers that chimed in. Let's see what the other lawyers had to say.
Contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received.
Really? Well, if everybody's in receipt of it and nobody disclosed it, is the judge going to put like 20 lawyers in the fucking hoosegow? I mean, The judge really needs to rethink what he just did there.
I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
All right, sir.
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
Well,
believe
I asked him, so I didn't ask you.
Yeah.
So, but I'm
not a fan of this kind of judge action, because being strong-handed against a lawyer, what's the purpose in the judge asking for this information or demanding or ordering this information? What's the purpose? He wants to take somebody to the fucking woodshed. That's the retribution. That's the only thing he wants for.
I'll leave it at that. Okay. All right. Take Mr. Steele into custody, please.
So Young Thug, or Jeffrey Williams, is sitting there. He's got his nice sweater on, and his lawyer's getting fucking arrested. He's getting arrested in court. See, take your coat off, take your watch off, take your wallet out. Make sure you get your keys. Give your keys to somebody. This is just wrong. During the middle of a trial, you take the defense, and it's not like the defense lawyer did anything bad in terms of outrageous conduct.
My client should go right to fucking jail!
May I say one thing, Your Honor?
Yes, sir. You certainly may.
You're a cunt. No, I'm just kidding.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
One of the things why he wants him to deny it right then and there is so he can appeal that ruling.
I've denied your motion, but I'll certainly take that under advisement, sir. We're going to be in recess for the next 5 minutes.
I just can't believe he did that, because he wouldn't reveal the source of who gave him the information about this particular witness going in chambers and having an ex parte communication. That can be, it can happen, and it can happen for a legitimate purpose. But at the very least, the judge should have said, look, I don't want you to tell your client, but here's what's going on. We're going to have a little in-chambers conference. We're going to make a transcript. At some point, we'll make this available to you. And I don't think that the judge was proper in demanding that he disclose of what Brian Steele knew or how he got that information.
I'm not the only one here. There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I have space allocations, as I told you. So
Essentially, there's 20 or 25 lawyers that want to come in and speak out on behalf of Brian Steele. And that can be kind of powerful. If all of a sudden you're really offending the defense bar, you know, one of the things that the judges or the lawyers can do is remove a judge for cause, or depending upon your jurisdiction, you know, here in Minnesota, we can remove a judge for any or no reason, once. And you got to be careful when you use that, because you could get a worse judge sometimes. So where are things at with Mr. Steele? Well, Colette Steele, his wife, I think it's his wife, filed a notice of appeal, also a motion to set aside the contempt, purge the contempt. I don't think this was the right thing for the judge to do. I think the judge was getting vindictive because he thought that something inappropriate happened. Maybe it did, maybe it didn't. But understand the indignation that Mr. Steele is experiencing. Because here you have a witness that's been sworn. There's been some testimony that's been taken. Now you take this witness, bring him into the judge's chambers, and you're not being given a transcript of what they fucking talked about? I mean, how do we not know that the judge is intimidating that witness with jail if he doesn't testify a certain way? And this is all about Kenneth Copeland, Lil Woody, or Nut, as he's known to his buddies, about whether or not he is going to testify and, about him cooperating and that kind of thing. Now, keep in mind that his lawyer was in that meeting. No doubt in my mind that his lawyer is the one that disclosed this to Mr. Steele. And Mr. Steele isn't coughing her up. So they're going to have a hearing on this on the 25th of June to determine whether Miss Bumpus, this fine fired lawyer, but she's going to be, probably questioned by the judge. And if she doesn't answer him appropriately, the judge is going to hold her in contempt. And then she goes to jail. It's getting a little out of control, don't you think? So we'll see you next time here at Criminal Lawyer Reacts. I'm Bruce Rivers, supported by, by all you guys. We really appreciate the support. So follow us on Instagram, follow us on Twitter, sign up for Patreon, and we'll see you next time here on Criminal Lawyer Reacts.
Yes.
It's drop a body and you wouldn't have to pay for lunch.
She's reading lyrics off of a song. She asked him, where does it say in the song, truly humble under God, right? She should not be able to go into the rest of the lyrics with this witness because it's really not relevant to anything. All it is just basically character assassination.
What if the police officer, for example, said, yes, Mr. Williams gave a statement to me and he admitted being there at the time of the incident?
Remember my cousin Vinny? He says, you shot the clerk. And he goes, I shot the clerk?
At what point did you shoot the clerk?
I shot the clerk.
Yes, when did you shoot him?
I shot the clerk.
I'm in the middle of a damn confession here.
Whoa!
I shot the clerk.
And if you're not able to flesh the rest of that out, it creates an impression in the jury that what was said at that moment is fact.
I didn't bring this up.
Okay,
No intention of playing it.
Mr. Steele, I do understand that. I really do. But
I just want to play the song.
But you can't at this point in time.
Yes, I can. It was.
When the judge tells you can't, you are going to get sideways with the judge if you just go against it. But I mean, yes, you can, and I kind of agree with him on this.
Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. And what he do? And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another episode of Criminal Lawyer Reacts. I'm Bruce Rivers, your board-certified criminal defense lawyer, coming to you with our pearl handle pistol cufflinks and our content genius who gave them to me, Michael Rivers. And today we're reacting to a little update on the YSL trial. A lot of things going on in this trial. Wife and Lucci, or Gucci, Finucci, Bamucci. So a lot of things going on, but before we get to that, this is brought to you by eForms.com. eForms.com, very effective way to avoid guys like me. eForms.com, you use it for power of attorney, you use it for a sales agreement, rental agreement, any kind of business agreement, anything where you need a signature and you need to be protected by an agreement, because sometimes you got to have things in writing. I put things in writing all the time. But guess what? If you go to eForms.com instead of calling me, you're going to have a professionally drafted legal document that will protect you, and you don't have to pay an arm and a leg for it. eForms.com, very effective way to avoid guys like me and protect yourself in just about every scenario. So eForms.com, go there. YFN Lucci, a.k.a. Rayshawn Bennett, pled guilty. And we're going to show you what a guilty plea is here first. First they do the waiver of rights, and then, then they go through what they call a factual basis. And he's looking at 20 years. So let's just kind of dial into the court.
Rayshawn Bennett, RAYSHAWNBENNETT.
All right. At this time, Mr. Bennett, Assistant District Attorney Christian has questions for you. Please speak loudly and clearly into the microphone in response to her questions. Ms. Christian, the witness is with you.
Thank you, Judge.
The first thing you usually in a plea is you go through your rights. You have the right to a trial, you have the right to be presumed innocent, and you have the right to cross-examine witnesses, evidence, have witnesses testify for you. You have the right to remain silent or testify, and if you choose not to testify, nobody can comment on your silence, that kind of thing.
Are you at this time under the influence of any alcohol, drugs, or any medicine?
No.
And the other part is to make sure that they're competent, because the plea has got to be knowing, involuntary, and intelligent. And if you're all high as shit, which has happened, not to me, but I mean, I've had clients that come into the court high. Court can't take a plea from someone who's high.
Do you understand that you're charged with the following offenses under indictment 23 SC 188921? Count 1, violation of the Racketeering, Influence, and Corrupt Organization Act, which carries a minimum sentence of 5 years, maximum of 20 years.
Now, I don't know why he's pleading at this point. A lot of times people see the writing on the wall, and then maybe they got some discovery saying this snitch is going to say this snitch is going to say that. So or maybe he struck a deal to cooperate. I don't know that at all. But there's a number of reasons why somebody like this would all of a sudden change their mind mid-trial and decide to plead.
Count 68, violation of the Street Gang Act, which carries a minimum 5 years, maximum 20 years. Count 69, violation of the Street Gang Act, that's minimum 5 years, maximum 20 years. Count 72, violation of the Street Gang Act, minimum 5 years, maximum 20 years. Count 73, violation of the Street Gang Act, minimum 5 years, maximum 20 years. Count 76, violation of the Street Gang Act, minimum 5 years, maximum 20 years. Count 77, felony murder, that's minimum life, maximum life without the possibility of parole. Count 78, aggravated assault, that's minimum 1 year, maximum 20 years in custody. Count 78, aggravated assault, that's minimum 1 year, maximum 20 year. Count 80, aggravated assault, minimum 1 year, maximum 20 years. Count 81.
This is kind of daunting. I mean, when you read off all these charges, these aren't just little charges.
81, aggravated assault, the minimum is 1 year, maximum 20 years.
And then you see him smile. That's not a good look in court, especially when you're dealing with such a serious case.
Count 82, aggravated assault, the minimum is 1 year, maximum 20 years. Count 83, possession of a firearm during commission of a felony, that's 5 years consecutive. The minimum is life with the possibility of parole, followed by 5 years consecutive. And the maximum you're facing under these charges in the indictment would have been life without the possibility of parole, plus 220 years, followed by 5 years consecutive. Do you understand that that's what you were initially charged with in the indictment?
Yes.
So, long story short, he's facing, without a plea, he's facing life without.
Do you understand that the state has agreed to no pros counts 1, 68, 70?
No pros is no prosecution. So they have agreed not to prosecute him for certain crimes.
72, 73, 60, 76, 77, 78, 79, 80, 81, 82, and 83.
Yes.
So, Ms. Christian, the only charge under this recommendation is count 69. Is that correct?
Yes, Judge.
All right. Excuse me.
He pled guilty to one count, violation of a Street Gang Terrorism Act. The rest of the charges are going to be dismissed. So he's looking at a minimum of 5, maximum of 20, and he's in custody. He's been in custody this whole time. So he's probably got how much credit? A lot of credit.
Have you reviewed this charge with your attorney and been advised of the minimum and maximum for the charge the one charge that you're pleading to?
Yes.
And do you understand that you have the right to either plead guilty or not guilty to this charge? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorneys, Mr. Finland and Mr. Banks, about all the facts and circumstances known to you regarding the charges, including any potential defenses?
Yes.
Do you need more time to speak with your attorney?
No.
Are you satisfied with their services?
Yes.
Do you waive a formal reading of the indictment, Mr. Finland?
Yes.
Do you waive any or all defects in the indictment?
Yes.
Do you understand that this
So they have to go through your rights, and that's what they're doing here.
is a negotiated plea, which means the state will recommend a sentence of, under count 69, the recommended sentence is 20, serve 10, balance probated, and the special conditions of probation are no street gang activity, no contact with any known street gang members or associates, no contact with the co-defendants, Reginald
So what does that mean? It means 10 in, 10 out. And, you know, if he gets a third off for good behavior, I'm not sure exactly how much time they get off in Georgia, but let's say it's a third off. So 10, you do 7 basically, and he's probably got 2 in maybe. So maybe he does another 5. So he'll be on probation for 10 years, and he'll be in custody for maybe 5 years. That's my guess.
Artez Carter, Justin Ushery, DeMonte Thomas, Tadrekus Glass, Rayvon.
So he can't have any contact with any of his co-defendants.
Boyd, Leroy Pitts, Rondavius Hawkins, and Derek Adams. No guns or replica guns. No gang affiliation or conduct associated with gangs on social media. You must be gainfully employed and no further violations of the law. Do you understand that those are the conditions?
Yes.
So no guns, no replica guns. So no videos with guns, basically.
And Mr. Christian, I just wanted to make sure that the record is clear. You said this was a negotiated plea. This is a negotiated recommendation, but it's officially and formally a blind plea. Just want to make sure the record is clear.
Yes, Judge.
Which means a blind plea. It's like an open plea, but a blind plea. That means they don't know what the judge is going to do. They have a joint recommendation, but the judge is free to do what he wants. And if the judge sentences you to the 20 years, like 20 in, you can't withdraw your plea. So you're taking a risk when you do something like this. And it really is chilling if the judge doesn't honor the agreement, honestly. It's like, if you're not going to do this, judge, why would you take the plea? Because a defendant's got to have some certainty that the agreement that he's struck with the prosecutor is going to be honored by the judge. Otherwise, why would you plead?
Okay. Do you understand that those are the statutory conditions of your
Yes.
session? Do you also understand that you are to have no violations of state or federal laws while serving out any portion of your sentence, to include any period of incarceration, to comply with all the rules maintained by county jail where you're housed prior to being transported to any facility within the Department of Corrections where you're designated to serve out your sentence? Comply with all the rules maintained by any facility within the Department of Corrections where you are designated to serve out the remaining sentence. You waive a right to appeal any and all terms and conditions of this plea agreement and the sentence imposed, as well as any right possessed in connection with OCGA 244410. And if you violate any of the special conditions, that the state is free to revoke the sentence and recommend any penalty allowable under the law.
And that's kind of a bitch, because if all of a sudden you don't comply with anything prior to getting sentenced, like you don't show up for your PSI, doing a pre-sentence investigation, that's a report that the probation creates about the background, about the offense, about finances, about everything related to this individual with respect to the sentence that's going to be imposed. Well, then if you don't comply with that, all bets are off. And you can't withdraw your plea. In other words, the prosecutor's not bound by their recommendation. They can do whatever they want. And same if he doesn't show up to court, or if he gets a new offense that happens in between then. So there's an incentive for you to kind of toe the line, because otherwise the prosecution's free to do whatever they want.
Including that you be sentenced to the maximum for the charge in which you plead guilty.
Yes.
Do you understand that in exchange for this plea, the state has agreed to write a letter to the Board of Pardons and Parole stating that the state would not object to the defendant being released from the Department of Carcerations the first time you become eligible or after 1/3 of the sentence has been served, whichever comes first, and you must comply with all lawful authorities of law enforcement.
So 1/3. So if he gets 10 years in and you do 1/3, that's 3 years.
Of law enforcement while in custody and have no further incidents from the date of this plea in any penal institution.
Yes.
And the state is recommending you get credit for time served at the time that you voluntarily surrendered yourself into the Fulton County Jail on January 13th, 2021 to present, to include any time spent on house arrest as required by law.
Yes.
So he's been in custody since January 2021. So he's already got that 3 years in. So he's not going to do any more time. That's why it all of a sudden became attractive to him to plead.
You understand that that is the recommendation that the state is making to the court?
Yes.
Do you understand that the judge does not have to accept this recommendation and can sentence you to the maximum?
Yes.
Basically, you heard the judge say it's a blind plea. In other words, he's not bound by the agreement. One of the things, one of the downsides of something like that is you don't know what you're going to do. You don't know what the judge is going to do. And there's an argument to be made that holding more time over his head is more persuasive to control his behavior in the future than whacking him now and then all of a sudden having him get out down the road. The prosecutor is going to go into what the facts of the case and what they would have proved. Because you have to have two things. Waiver of your rights, which we just kind of watched that, and it's kind of pretty boring. Now we're going to see what they would have proved at trial.
Your Honor, had this case gone to trial, the state would have shown that on December 10th, 2020, this defendant, Mr. Bennett, was gifted a 2021 Mercedes-Benz Maybach by his record label. The defendant drove that vehicle and picked up his co-defendants, Rayvon Boyd, Leroy Pitts, and the decedent, James Adams. Boyd, Pitts, and Adams traveled up from Miami, but were visiting the defendant, Mr. Bennett, in Atlanta. The defendant then drove around the city of Atlanta in that vehicle. Although Bennett himself did not personally possess a firearm, he was aware that there were firearms in the vehicle, to include 2 assault rifles. At some point, defendant Bennett drove to the area of Dimmick and People Street, located in Fulton County. While traveling down Dimmick Street, after passing several individuals who were standing on the street, this defendant stopped his vehicle. The individuals on the street and the individuals in inside of his vehicle began shooting at each other. This shooting is captured on.
When you have this kind of conduct, I mean, it can only go south. And so he's striking a deal where he's going to get, probably out almost time served, unless the judge is going to do something different.
Shooting is captured on surveillance video, and the video reflects that after defendant Bennett stopped his vehicle, co-defendants Boyd and the decedent, Adams, opened the door to the car and began firing assault rifles at Kevin Wright, Nathan Bedford, and others that were on the street at the time. The video shows Nathan Bedford and Kevin Wright and others shooting back at the vehicle. During the exchange of gunfire, the decedent, James Adams, sustained a gunshot wound to his torso that caused his death. After shots were fired, defendant Bennett drove off in the Maybach, which then turned onto People Street. The individuals in the vehicle attempted to pull decedent Adams' body back into the vehicle, but were unsuccessful. As a result, they left his body on People Street and left the scene. After leaving the scene, he drove the vehicle to his father's house to conceal the vehicle following the shooting.
So you got a shootout, then he conceals the vehicle, and everything's caught on video. Remember when I was telling you, there's cameras everywhere. There's cameras at the mall, there's cameras at Walgreens, There's cameras, as you walk out of a courthouse. Almost every industrial building that you see has got cameras all the way around it. Every bar has got cameras, multiple cameras inside and out. So, that's one of the ways I won a homicide a while back is I just went through all the video footage, like painstakingly. And I was able to show that my client didn't do what he was accused of. But I'm telling you, if you want to commit a crime, be prepared because it's going to be on candid camera.
The facts and evidence would further establish that defendant Bennett is an associate of the Bloods, a criminal street gang operating here in Atlanta and elsewhere. Defendant Bennett demonstrated his...
Now here's the other thing. He's admitting to these facts. He's admitting that he's a Blood. He's admitting that there is a gang called YSL. He's admitting that this is a crime's benefit for the benefit of that gang. I don't know if that's going to mean that they can compel him to testify, but it's quite possible.
Association in part by appearing in rap videos with members of the Bloods while displaying gang signs and wearing gang colors. The basis of the state's reduction, Judge, is essentially this defendant has no criminal history. We have spoken with the family in this particular case, and they have maintained throughout the course since this incident occurred that they are on board with the recommendation. They are more than amenable to the defendant's request at this point. And they have also, as
that's another thing. A lot of times, in fact, every time, the prosecutor will say, I can't do that deal because the victims won't go for it. What the victims say or their wishes are is not determinative in any particular case, but sometimes, and quite often actually, their wishes are taken into account.
You are aware from the facts is the defendant's level of culpability in this particular incident. He was the driver of the vehicle, and he didn't have a weapon during the time of this incident. And this is out of the 80-something.
So she's justifying why she's giving this particular defendant a lower sentence. And that's pretty common.
Yes, Judge.
And what is that charge?
Violation of the Street Gang Act.
All right. For count 69, Mr. Bennett, violation of the Street Gang Act, your sentence is 20 years to serve 10 years with the balance on probation.
So that is YFN Lucci pleading guilty, and he's looking at 20 years. But not really. He's looking at 10 out, 10 in, serve a third of that, which means he'd probably already have everything served. Let's switch gears a little bit. And now we're going to Brian Steele and him arguing in court about the lyrics. Now, the prosecution has picked and chosen little bits of things to play. And it's Brian Steele's argument that they're taking things out of context. So when you do that, guess what? You sort of open the door to, there's a rule called the rule of completeness. And so statements of the defendant are not admissible unless, by the defense, unless the defendant testifies. Okay? So, like, if I have a case and Michael's on trial for murder, and Michael said a bunch of good stuff, like he denied, in an interview with the cops that he killed anybody, the prosecution could bring up that interview, but I can't because it's hearsay unless he testifies. So the argument here is, okay, the state put this in. Now I should be able to flesh that out because under the rule of completeness, it gives the jury the true story, not this out of context bullshit. Okay, so let's hear what Brian Steele has to say.
Introduce lyrics out of context on redirect under the rule of completeness and under truthfulness to this jury. I would like to do what you already ruled and play the song. And I don't even understand how we're at 24-6-613 prior consistent statement. That's not even close.
So he's saying that there's other statements that the defendant made, that these statements made in the song are prior consistent statements, which I kind of agree with Brian on this. How can you say something that he produced, as art, is a prior consistent statement.
I mean, we're talking about, you're saying, okay, it's snowing, and we're talking about, well, let's go, so since it's snowing, let's get our pails and shovels and dig up the sand. I mean, this is crazy, their arguments. So I didn't bring this up.
Okay.
No intention of playing it.
Mr. Steele, I do understand that. I really do. But
I just want to play the song.
But you can't at this point in time.
Yes, I can. It was.
When the judge tells you can't, you are going to get sideways with the judge if you just go against it. But I mean, yes, you can, and I kind of agree with him on this. To what extent if the state is misrepresenting something with just taking things out of context, you should have the full and fair opportunity to correct the record.
Okay, but you know what? It's still inadmissible at this point. It's not admissible at this point. I would agree with the state under 801, 24-8-801 A through C, 802 and 613.
At some point, the confrontation clause has to
Those are rules of evidence that he's talking about.
Speak in this courtroom. The state of Georgia, ass and level. Words made by Mr. Williams. I want to put those words in proper.
Okay, but you won't be able to do it through him. It's objectionable.
Right person.
It's objectionable at this point in time. I'm not saying that it's not. I'm not, like I told you before. It's not that it may not be objectionable at this point, but if evidence comes in for different reasons, Mr. Steele, at this point in time, it's just not coming in. I'm not saying that it won't come in at some point in time.
This court is handcuffing the Constitution. That I move to strike everything said by Mr. Stevens in its entirety because I can't confront him.
That's a problem. I think that is a problem. And I don't see what the danger is in giving the defense a lot more latitude. You can't get the defendant's statement in your case in chief unless the defendant testifies. You just can't, the defense. And that is a hard and fast rule. But you can't get it in through another witness unless the defendant testifies. So you've got this detective who's testifying about all kinds of other crap, and you should be able to say, okay, we talked about these particular words. Let's flesh this out and put it all in context. I completely agree with Steele on this.
You have the awesome power to control these proceedings, but the state of Georgia wide open that door. I didn't mention anything.
Okay, but that does not make the evidence any less inadmissible. It doesn't.
They took words out of context, and I want to put the words in its entirety the way they are. You should be able to let me see the road to do that.
That's a problem. I think that is a problem. And I don't see what the danger is in giving the defense a lot more latitude. You can't get the defendant's statement in your case in chief unless the defendant testifies. You just can't, the defense. And that is a hard and fast rule. But you can't get it in through another witness unless the defendant testifies. So you've got this detective who's testifying about all kinds of other crap, and you should be able to say, okay, we talked about these particular words. Let's flesh this out and put it all in context. I completely agree with Steele on this.
To control these proceedings. But the state of Georgia wide open that door. I didn't mention anything.
Okay, but that does not make the evidence any less inadmissible. It doesn't.
They took words out of context, and I want to put the words in its entirety the way they are. You should be able to let me see the road to do that, Your Honor.
I just can't let you do it right now, Mr. Steele. It's because the state's objected to it, and I agree with them under 801 A through C.
Let's look at 801 A through C.
This is not applicable, Your Honor. The state of Georgia said this is what Mr. Williams said. I'm saying actually what he said was this, and I'm putting in the completion of the story. You know what this song is about? It's about coming from nothing. It's about telling your kids, not that you're riding around with a body, it's about telling kids, if you live under the circumstances that a gentleman like Mr. Williams did, you may have to kill somebody because they're going to kill you.
Wow. It's so inspirational. We're not buying, his alternative explanation. But at the same time, I do agree that he's got the right, and it should be, the state shouldn't be allowed to just cherry pick what they want. You need to be able to flesh that out.
It's self-defense. The state of Georgia wrapped all that up in little lyrics and misconstrued what they are.
But here's the thing. How is he going to get the meaning of those songs in through anybody else? Except for his own client. I mean, you can't do it through the detective. Detective doesn't know fucking shit about the nature of the song. I can't imagine he's going to want to do it through the snitch, because the snitch isn't going to be able to give you what you want because he's giving everything for the state, right? So he wants to just play the whole song and then be able to argue about it later.
I have every right I need to put this in. And it's not going to say later, Judge, this trial, I know, I've never been in a case like this. This trial may go on until Super Bowl next year. I don't want to do it in 7 months. It's right now, and I should have the authority to do it, Your Honor.
And I don't disagree with him. I mean, when you have a really long trial like this, you ever hear of the primacy effect? You see these glasses at the beginning of the trial, and all of a sudden 9 months goes by, you see these again, you're like, what the fuck are those? You don't remember it. So if the state has played or used some of the lyrics now is the time to put it all into context. So Steele's making an excellent argument here.
I'm doing everything that I know to be upfront. I give everything I don't have to give. I give everybody a heads up, and it gets spun around. I get to play this song, the song I want to play, and I ask you not to keep doing this and listening. Once you rule, it's coming in, which one? The state was saying before lunch, I'm somehow changing the lyrics. The lyrics don't change, I tell you that. Now it's all of a sudden another reason. Your Honor, you have ruled. I use your ruling. I embrace them, and I am correct. There has to be a point that we have traction here, too.
This whole battle about putting lyrics into a trial like this, I'm totally against it unless they talk about specific events. If it's just general character evidence, he talks about killing, he talks about this, and just being that guy. If they're just general character bullshit, they shouldn't come in at all. But if they do, and the defense wants to flesh it out, Mr. Steele is absolutely right.
It was mentioned before Mr. Steele it from his memory. Miss Love was saying, you know the song, and here it's the song. Here are the lyrics. I want to put in the actual song. The way I want to put it in the video, and then we're done. But Judge, to exclude it, it makes it look like I'm conceding it, and I'm not. And I would not. And to hide behind a hearsay statement when you open the door on that specific statement. I was thinking about this over lunch. What if the police officer, for example, said, yes, Mr. Williams gave a statement to me, and he admitted being there at the time of the incident.
Remember My Cousin Vinny, where he says to Ralph Macchio, the sheriff does, he says, you shot the clerk. And he goes, I shot the clerk? Yeah, I shot the clerk.
When'd you shoot him?
What?
At what point did you shoot the clerk?
I shot the clerk.
Yes, when did you shoot him?
I shot the clerk.
Hey, Dean, we need you out here. I'm in the middle of a damn confession here.
Whoa! Wait a minute!
I shot the clerk.
Clerk. And the inflection in his voice was, wait a second, I didn't shoot anybody, but he actually said, I shot the clerk. And if you're not able to flesh the rest of that out, in the moment, it creates an impression in the jury that what was said at that moment is fact, when really it's not. And that's what he's talking about here. We just heard Brian Steele talk about evidence that he's trying to get in, and let's see what he's responding to. We're kind of doing this in reverse a little bit, but it makes more sense to do it this way. So let's see what the prosecution was doing and how it makes sense to what Brian Steele just talked about.
I was smoking Scotty, but not Pippin. I taught my son how to stack that shit to the ceiling. Also, a part of dropping jewels
Yes.
is drop a body and you wouldn't have to pay for lunch.
So this is a problem, I think, for the... I completely disagree with the judge's ruling. She's reading lyrics off of a song. She asked him, where does it say in the song, truly humble under God, right? She should not be able to go into the rest of the lyrics with this witness. She just shouldn't be able to, because it's really not relevant to anything. All it is just basically character assassination.
I told my dog I'm riding, whether he right or wrong. I done got big. They record my life through a drone. I told my to stay behind me.
There should be objections, though, honestly, because he's not objecting.
My zone. She like, how you ain't never wrote a song? You riding for life, then I just rather die alone. Bought you a spot, now you don't. Never got a gun.
What the fuck is the purpose of her reading these lyrics into court for him? You know, I don't know if the lyrics are actually in evidence at this point, because I don't know if they are or not. But what's the purpose of her asking this witness about these lyrics? All it is character assassination.
Yeah, I told my I'm dropping the jewels on him. You gotta go through that with your heart. You can't snooze.
Objection, compound question. Objection, improper question. Objection, relevance. Why aren't there any objections here?
Are those also words in the song Dropping Jewels?
Yes.
Who the fuck cares? I mean, where's the objection?
Is there any part of what I just read that refers to the defendant Williams being truly humble under God?
Objection, call for speculation.
There we go.
I'm going to overrule the objection.
You may answer it.
Number one, that is speculative. And number two, it's irrelevant.
Answer it.
You said, do what you just read, talk about God? No.
Okay. Is the line, you gotta go through this with your heart. You can't snooze on it. It's bad. You better get rid of it or lose on it. I know you heard that old saying about bad fruit on you. If you can't beat them.
How in the hell is she allowed to just go through this song with this guy and then not allow the defense to flesh it out? What's the point? I mean, there should be objection after objection after objection. How the fuck is she allowed to do this? You know, it is. There's another thing too called more prejudicial than probative. What is this probative of? Of the issue of truly humble under God, whether these statements are consistent with truly humble under God. We've already established that the song isn't that way, right? So what? I mean, so now it's, you know, repetitive, it's irrelevant. I mean, I think the judges should have taken some control here. So you can see, you know, what Brian Steele was objecting to, or pleading with the court. Okay, let me put the whole song in. I mean, she talks a lot about, you know, a lot of different lines in the song. But on recross, you know, hopefully he cleans some of that up. So this has just been our kind of a very technical update on the YSL case. So we'll continue to follow it, and it's going to be a long, long trial. So we got a lot more to go. So we'll see you next time here on Criminal Lawyer Reacts. I'm with Michael Rivers, your content genius. I am, you know, follow us on Instagram, follow us on Twitter, sign up for Patreon, and we'll see you next time here on Criminal